Hey everybody, Richard Seller here with another update video on everything employment law. Today's topic, if I had to give it a caption, is what's my employment case worth? And it's a question that we get all the time from our clients and prospective / potential clients because they want to know what they're getting into. And, TV and movies have really ruined realistic expectations of what clients are entitled to in the employment arena. Now, don't get me wrong. We've had cases over the years that have settled for close to $10 million, and we've had cases over the years that have settled for, a dollar and a pack of gum. And it really obviously depends on the facts of every case. But, the one line I always share with clients is this, is I am in the make whole business. I'm in the business of trying to make you whole if you've been illegally terminated or had your wages stolen. We're not in the revenge business. And oftentimes the concept of revenge is something that drives a client to want to continue to have expectations that are not supported by the law. And it's understandable. I mean, this employer, you've come to us for a reason, has done something terrible to you, has taken away your livelihood, and you're seeing red and you're seeing revenge. But what I always encourage clients to do is just step back and let me handle the emotion. Let your lawyer handle the emotion. And this needs to become a business decision for you and your family. It's a business decision, which means as hard as it is, you need to remove emotion so that you can make informed decisions. And a classic story I give is about a client who was insistent in his mind that he wanted $175,000 on his case. It wasn't worth $175,000. The gentleman was not a high wage earner. He was working at a fast food restaurant, and although what they did we believe to be was illegal, the damages he had suffered were not substantial because he had found a job 2 weeks later at another fast food restaurant. And so in any event, we got them to offer him $75,000, which was a nice settlement for the facts of that case. But he was insistent in his mind that he had this $150,000 number. And no matter what I told him and explained to him that, even if we were to go to trial and win, you still may not recover this amount, he said no. What happened the following day was that the court in the case found in favor of the employer. So the client went from getting $75,000 to nothing. And what was even worse, unfortunately for the client, is that when you lose in an employment case, which many clients don't want to listen to or understand, is that you may be obligated to pay the other side's fees and costs. There's risk in litigation, and we're always very clear with our clients on that. So he actually wound up owing the other side $25,000. So that's quite a swing. So, practice point for me. We always tell our clients what the risks are, what the benefits are, what the upside and what the downside is to every case. But going back to the initial question, what is my case worth? Okay, so in an employment case, the measure of damages to start is what the lost wages are from the date of the firing through either the settlement or the trial. So let's say you were fired on January 1st, 2018, just picking a date, and the trial is January 1st of 2020, and you were unable to find a job. If we were to go to a jury and win, you would be entitled to, as a starter, your back wages from the date of your firing through the date of trial. So if you were making, let's say, $50,000 a year, it was 2 years, you'd be entitled to $100,000 in lost wage damages. Now, there's something called set-off, which means if you go and find another job after you've been fired and you're making the same or a comparable wage to what you were making, your wage damages may be cut off or reduced. So using my example of you were making 50 grand a year and you were fired 2 years ago, but after 4 months you found a job making exactly the same or more, your wage damages may be limited to that first 4-month period, okay? So clients often forget or don't understand that concept, and it's important to understand. The law requires you to go out and what's called mitigate your damages, to stop the damages by looking for work. So if you do that, that's a good thing. And oftentimes clients get upset and they say, well, why did I go out and look for work? Because you got to feed your family, and litigation should never run your life. When you're fired, There's a couple ways you can go. We can sit down and not do anything, or you can get up, stand up, and go look for work, and that's what we always encourage our clients to do, and that's what the law requires. That's economic damages. Now, let's assume you've been sexually harassed or you've been discriminated against. The law permits you to recover what's called compensatory or emotional distress damages. Now, oftentimes, the juries and the courts are going to require that you actually be able to document those injuries rather than just saying, for example, I can't sleep at night, or, I've lost my appetite. And this is normally documented where if you've gone to therapy or as a result of what's happened to you, you're now on medication and you're regularly going to a mental health professional, things of that nature. And those damages, if the jury awards them, can run anywhere from $0 if the jury doesn't feel you've truly suffered emotionally to millions of dollars, just depending on the nature of the injury. And we have a claim that we're dealing with right now that deals with a very violent sexual battery, and the emotional distress to the client was terrible. She was beaten and bloodied after refusing to give in to sexual advances. And, as a result of what happened to her physically and emotionally, she's been treating, she's been depressed, she's been suicidal, she's been Baker acted for what happened. And we think that's really going to resonate with the jury to say, hey, that can happen. So that's emotional or compensatory damages. And finally, I'm going to call the myth of punitive damages. I call it the unicorn. Clients always want to say, get punitive damages. And believe me, as your lawyer who works on contingency, I also would be very happy with the punitive damages award. However, they're very rare, and courts and juries rarely impose them in employment cases because we have to show that, in essence, the employer not only was aware of the law, but that they knew of your rights and purposefully and intentionally disregarded them to injure you. So on its face, it sounds okay, but it's a really tough standard to prove. Now, in every single case where it's available, we ask for punitive damages, but the reality, folks, is that you're looking at 1 in 50 of a jury actually awarding them. And the only way you're getting punitive damages is if a jury awards them, okay? So that's kind of the lay of the land. There's so many different variables that go into evaluating a case and determining, what the client is actually owed. I didn't even get into the analysis that the defense side does today when they say, well, we've got a 50% chance of winning at least, so we're going to, reduce the amount of money we're willing to settle or pay by 50%. And if your client wants more, well, we need to go to a trial. So I'll do another video shortly on, how the cases work and what happens and how the case evolves so that you understand what's involved. But I wanted to give a little or short speech today on how damages work and what you can really expect in these types of cases. So I hope it's helpful. Tell your friends, tell your family. If anybody has suffered something in the workplace, we're here for you. Hope you guys are enjoying the videos and have a great day.